I'm talking about spousal maintenance, aka alimony, in Texas, and in the context of an actual case that occurred in Austin in 2023. This is a good case because this is recent law, and if we're talking about a case in the state of Texas, then that means even if it's in the city of Austin and you reside somewhere else in Texas, this is a common law system in the United States. So what comes out of these opinions is the state of law throughout the state. Okay. So I thought this was a good case because I read through it really quickly. I just want to talk about the facts. Basically, there's a woman named Jennifer who got divorced from a Bradford. And then the outcome of the case she was unhappy with. So Jennifer filed an appeal against Bradford. And it went to the Court of Appeals in Austin. And so at the beginning of the case, and again, all of these cases that I talk about on the Partis Friends YouTube channel are available free to you. If you go to Google Scholar and put in Texas cases or whatever state you're in, if you put in those that state, you can look at the cases freely on Google Scholar, which is a great service because these are primary sources of law. So Jennifer filed an appeal saying that the lower court, meaning the original trial judge that decided on the outcome of her divorce, made a mistake, abused its discretion, in other words, made a mistake because they did not award her alimony. Actually, it's called, in Texas, it's called spousal maintenance. So that's what she would be paid by her spouse to support herself for a period of time after the divorce is granted. So this is the factual background. The couple got married in October of 2009. They did not have children, and they stopped living together in 2018. And he lived in a separate property home that he had owned prior to the marriage, and she lived in a condominium in Illinois that they bought together as a vacation home. He filed the divorce in 2020. She filed a counter petition and asked for alimony. And Jennifer has a biology degree and other certifications. She did not work, though, during the parties' marriage, and she did not become employed during the case. And I think that that's a really important key. She did not become employed or get a job during the case. He worked at Texas Instruments, and he earned enough money, including bonuses and stock options, and she did not need to work during the marriage because he supported them. Now, the last hearing in the case occurred in February of 2021, and the people that testified in the case were Jennifer and her mother, who testified. The mother said that she had loaned Jennifer $37,500 during the party separation, so from the time they filed for divorce. And Bradford had also given her $50,000 during the case. And the trial showed exhibits including information about their income, their living expenses, and their budgets. And the primary issue at the trial, and if there is a trial, you know that there's a primary issue, was that the parties did not agree about how to divide their money or their assets in the divorce. And a huge issue was that she wanted to have spousal maintenance or alimony as a part of the outcome of the case. Now, Jennifer requested a 60-40 split, meaning she would receive 60% of the assets, he would receive 40% of the assets, and she requested $5,000 monthly for a period of 5 years. So they were married between 10 and 20 years, and so they said that they calculated that $5,000 based on the percentage you're allowed to award in the family code. If you go to this family code section 8.054A1A, talking about basically the limits on spousal maintenance in the state of Texas. So in this case, that would be limiting the amount of spousal maintenance to the lesser of $5,000 or 20% of the spouse's average monthly gross. So she's asking for $5,000 a month is what it comes down to. Now, Jennifer testified that she was not employed and that she needed $12,000 per month in living expenses, And she testified that she was last employed in 2008 as a medication aide, and she'd worked as a certified nursing assistant, but she's not interested in doing that. She also testified that she had a dental assistant certification, but it did not transfer to where she was. She had photography certifications, but she had not done anything to try to do that. She had partially completed a real estate course, but did not pass the portion of the test. She last called to try to reschedule retaking the test. So they're talking about basically what she testified to regarding her not working during the party's marriage or separation. She explained that she had businesses that were shut because of the pandemic. She did not have time to look for a job because of the pending divorce. She, however, admitted to going to stores and restaurants and taking riding lessons during the pandemic. She was leasing a horse on a month-to-month basis, which she testified was her therapy, at a cost of around $1,850 monthly for the boarding of the horse and the lessons. She testified that going forward, she hoped to work in law or finish her real estate certification, and admitted that she probably would have plenty of money to live on for some limited amount of time if the trial court divided the marital estate as she had proposed. Now, in the final decree of divorce, the trial court awarded Jennifer property in its division, but denied her spousal maintenance. They awarded her the condo, which was worth over $250,000. They didn't give her any debt. They gave her the Escalade and retirement funds with a value of over $150,000, mutual funds and stocks of over $250,000, and she just received a credit card debt of $20,000. She filed the appeal, okay? So now I want to say that the way that this is worded, this opinion, it definitely sounds like you know where they're going, which is, we do know. Jennifer ultimately does not win this appeal. They say basically, no, we agree with the trial court, she's not going to get spousal maintenance. And sometimes looking from an outsider in, looking at Jennifer, it sounds like they're basically drawing a picture of Jennifer as being somebody who had a lot of possible opportunities but didn't really follow through with them, and that she had $12,000 in monthly living expenses. Keep in mind that this is a court delineating a record that came out of a trial, and that there could be a lot of backstory to what really is going on with Jennifer. We don't know. We don't know what kind of arrangement she had with her spouse, what kind of hardship she had with her spouse. We don't have any facts about, in this so far, what led them to getting divorced. We just know what they're telling us, which is that basically Jennifer wasn't working or gainfully employed. So we can easily, as outsiders, form opinions about Jennifer, but I would say to hold off on doing that. We need to recognize there are blind spots where we are concerned about what we really know about Jennifer and Bradford, and I'm not going to personally vilify either one of them. We're analyzing this just to know the state of the law in Texas in 2023. So what the court says, the Court of Appeals in Austin, it says, a trial court's decision to award or not award spousal maintenance is reviewed under an abuse of discretion standard. So that's important, because what it means is we, as the Court of Appeals, are going to give great deference to the trial court, which is one of the reasons why the trial court, those judges that sit in the district courts throughout the state of Texas, have a boatload of power, because you cannot overturn their decisions, even if they are the wrong decisions. You cannot overturn their decisions unless you can prove an abuse of discretion, which is really difficult to do. So make no mistake that those judges that sit in the district courts, they have a great deal of power, and they can make decisions that will impact you financially for your entire life in those courtrooms. Okay. So basically, when deciding on whether one of the judges in the trial court, the judge in this case, abused its discretion or made a mistake, we look at whether the court had enough evidence to decide to not give Jennifer the spousal maintenance. So then they quote the spousal maintenance rules, which is, again, this is alimony basically in the state of Texas. You award post-divorce spousal maintenance in a suit for marriage of periodic payments, basically the future income of a spouse to support the other spouse. This is intended, this is the most important part here, I think, of this entire clip. This is intended to provide temporary rehabilitative support for a spouse's ability to support herself has eroded. It could be himself, by the way, himself or herself, has eroded over time while engaged in homemaking activities whose capital assets are insufficient to support. So basically, they've become engaged in homemaking activities, and their money cannot support those. So you need temporary or rehabilitative support. This is serious. A person who's been with someone else for a long time, has formed a family with them, may have relied on them financially, and they really may need temporary or rehabilitative support for a period of years. That's why this law exists. Now, in this case, the parties were married over 10 years, and that's the threshold. You have to have been married 10 years in order to apply for spousal maintenance in Texas. She was eligible to ask for it. She says she lacks sufficient property or the ability to earn sufficient income to provide for her minimum reasonable needs. And that's what you have to prove, is that you do not have the ability to provide for your minimum reasonable needs. And she had to also, they say, rebut the presumption that the spousal maintenance is not warranted by showing that she exercised diligence in earning sufficient income to provide for her minimum reasonable needs or developing the necessary skills to provide for those needs during the parties' period of separation and during the time the suit of dissolution. So basically, what this is saying is you have to prove that you exercise diligence in earning money during the separation. You exercise diligence in earning money during the separation, and you did not have success in earning that money. You need to try to get a job during your pending divorce, which is very, very difficult to do in some cases. If you're coming out of an abusive situation, you may be mentally paralyzed and having to rebuild, and that can be a very difficult place to get a job, but that is what the law calls for. So then you see the trial court in this opinion go on to say, did they abuse their discretion in not giving her this? They said Brad for salary, and he had a huge disparity of income. Her monthly expenses were $12,000 of the nature of the assets that the trial court awarded to her. So basically, she basically has $12,000 in expenses, and just because she has been given property, that does not disqualify her from getting spousal maintenance. Because, for instance, she needs the condo. The investment accounts and stocks were not, these are not income producing assets or cash. So she's simply seeking temporary and rehabilitative support. So the court says that Jennifer, though, and this is where they put forth their opinion, I feel, Jennifer failed to address the statutory presumption that spousal maintenance was not warranted, and the evidence supporting findings that she had not exercised diligence. So she needed to show that she exercised diligence. The parties were separated for 6 months prior to the pandemic. Jennifer, who had a college degree and other certifications, admitted she had gone to restaurants, shopped in person, and gone to her riding lessons during the pandemic, but that she had not applied for any jobs or any virtual jobs. So basically, they're saying she had fun during the pandemic and didn't apply for jobs because she lacked exercising diligence in trying to get a job. She did not rebut the presumption that spousal maintenance was not warranted. So that's what they found. She said that Jennifer had relied on a case where the wife was given spousal support in the McFarland case, but the Court of Appeals said no. In that case, the spouse began working outside the home after the divorce was filed, and the trial court concluded that she had exercised diligence in attempting during the pendency of the divorce to obtain suitable employment, and she needed retraining or education in order to develop the necessary skills to become self-supporting. The trial court also concluded that the spouse had a limited earning capacity of only $7 to $9 per hour. So in that case, the spouse was less able to make money than Jennifer in this case. So ultimately, Jennifer lost, and they agreed with the lower court, and Jennifer did not win spousal maintenance. And that was the outcome of this case, and that's kind of how a court will go about, the Court of Appeals in Texas will go about deciding if they should allow the trial court to reject alimony or to keep alimony. And hopefully that gives you a better idea of how this kind of question would be considered in a case like yours. Our theory at Partis Friends is to try to come to an agreement with your spouse, because litigation like this is hard. It's a drain on your income in and of itself. It's a drain on your life. It's much better to try to come to an agreement for the family overall. And that's what we would advocate for every day of the week. Thank you so much for stopping by. And if you liked this or you found it useful at all, please consider subscribing to the channel. Have a great day.